Good morning. My name is Daniel Emerisis, and today we are doing beta test 3, known as video number 10, for something that is called motion. This is filming a motion. It is much more equivalent to making a chess move than a motion filed in court. But at the same time, the inspiration behind it came from multiple judges that continue to tell me, see, I'm doing like a robot thing because I'm getting used to the dictation aspect of it. So the truth is that in this video, I'm able to express to you the nature of what I'm doing, while at the same time responding to what I need to do. You're also able to see how lawyers make money artificially through very, very, very scrupulous means. Now, what I'm about to do right now is, first I'm going to read the original email that Matthew Smora sent to me, because that needs to be documented. I might skip over it and go into my response to him, because in the previous video you can see what he said. And I will read live without opening it, because last night he sent me an email and I simply was a little too stressed out from not seeing my children and the quantity of issues and work that I have to do. If you do not see a video filmed live, that means that it was filmed while I was sending out letters. So for example, there were 17 videos filmed that were not posted yesterday. And how many were posted?
4.
4 were posted, so 21 letters total. An average attorney, letters or motions or important data that needs to be done, an average hardworking attorney can produce maybe 5 of those a week, given the amount of context that needs to go into them. But with the use of Casper, CATS, and other proprietary systems that were invented by me in order to circumvent the paradoxes that are created in court in order to prevent honest human beings to represent themselves and dishonest human beings to pay dishonest lawyers to do dishonest things. So I thought that it was very important for everyone to understand that my goal is, A, I don't even print out a sheet to read off of. But that is not to say that human beings that film motions in the future can't read off a piece of paper. They just have to be able to orate themselves and prove that it is their words. So for example, a motion filmed, so filming a motion will replace sending or receiving emails. Why? Because communication needs to be done without redundancy. And if you film a motion, you very clearly state your position until you film another motion that changes it. With email, the ambiguity of the context of what is trying to be conveyed is lost in the communication redundancies. And the quantities of emails that need to be reread in order to understand the context of what the person is talking about is asinine. But if you see what I'm about to do, you will see me end a very, very scrupulous lawyer's actions via filming of one motion. So let's see if it works, because now what I'm going to do to you, for you, is read to you what I wrote to him and then read what he wrote as his response. And all of this could have been avoided with one text message or an email from my wife to me saying, do you have the boys, whatever, whatever. But because Matthew Smora gets paid only when there is a conflict, he will choose to create the conflict and use a restraining order that's in place to avoid the reality of saying, Your Honor, my client and her husband, ex-husband, whatever it is, who is the plaintiff in the domestic violence case, but I'm the defendant in the family matrimonial case because my wife not only beat me for 5 years straight, she also secretly filed for divorce while pretending and crying that she wants to stay married. Does that make sense?
Absolutely.
All right, so let me go ahead right now and read to you, ladies and gentlemen, my, while I say this, can I get the other laptop that has my email preloaded?
Mm-hmm.
That one has it on the email client, right?
Yep.
So, ladies and gentlemen, when you're doing work, you must give yourself a little bit of a break. Not in the sense where you have to stop working and take a break, but be a little bit realistic. So, for example, I was born on Friday the 13th. So I wanted to make the final grand reveal of what the meaning of this channel is about on Friday the 13th. So I was able to carefully plan approximately 15 years in advance to make sure that today's date is Friday the 13th and it falls in line with the actions of the human beings around me. You might not believe what I'm saying, but believe it or not, I do not give a flying fuck. And the biggest difference between myself and most of the people that you see on YouTube is I speak the truth without... Oh, and we have something that came in from the courts. So we'll be able to do two things at once. Now, after I'm done reading my email to Matthew I sent him last night, what I'm going to need for you to do is get the recorder out so I can immediately respond to... Not yet. Okay? My instructions were after I read the email from last night, you will need to get the recorder out.
Okay.
Jamie and I are making a lot of progress by her no longer being on camera, which means that she is no longer a part of my digital life. That is a very big weight lifted off of my shoulders and apparently off hers. Is that true?
Yeah.
You could speak, Jamie. Yes. Okay. So the only problem is she's only able to do one thing at a time. But hopefully she'll be able to have a conversation with me while working at the same time.
Yeah.
Clearly, based on the way we filmed the YouTube content, there was a series of circumstances that came up that made it extremely hard for me not to be very frustrated with her on camera. And that really led to an organic positioning of the way it's going to be for the rest of my life, where Jamie will be behind the camera. Agreed?
Yes.
Excellent. Now, even though I'm the boss, Jamie is a very important part of my business, where in many aspects I would call her my partner. We are not in a romantic relationship, and the only reason I've even stayed one night here is because of the fact that I've been left homeless and made illegally separated from my children. That is the only reason. Is that correct, Jamie?
Correct.
But we have a world full of people that believe that you and I are romantically involved and chose to live together. Where in reality, there was a full court case where Matthew Smora said, this is his girlfriend, he's staying at her house, he has a place to stay. All of that was a lie. So Matthew Smora has no problems with lying because that's the information he received from his client, he's going to say. But his client is going to say something very different. And you will see at the end of this case where the disparity comes in, because I will be able to show in the deposition, did you see this email and this communication? And based on what Mallory says, we'll be able to see whether or not she actually had all the information before making the decisions that she made, or was anything held back. That being said, let's go ahead and start reading. Matthew, your February 12th correspondence is deeply concerning. You know, what I'm going to do is I'm going to quickly read his so that there's inner context. And this is why this is a beta test, and the final product is going to be the master one. And once the master one comes in, then the rest of them are going to be master beta tests. But right now it's just a beta test. Now, beta test 3. Mr. Reeses, it has come to our attention sent yesterday at 11:19 a.m. Mr. Reeses, it has come to our attention that you impermissibly removed your children's ski clothing and related items during one of your recent police escorted trips. Your children are in need of these items immediately, and I'm sure you will not want to deny them access to their belongings. Therefore, please make arrangements to return all of the children's ski clothing and accessories to the Livingston Police Department today. Matt Smora sent from my iPhone. Then he sent an email saying, not children's school clothing, but children's ski clothing, because the title was incorrect. He was so hasty and sloppy. Here's my response. Sent at 6:35 p.m. Approximately half an hour after the filming concluded, would you say? Maybe 45 minutes?
Probably.
Because it took a
about
little
that.
bit of time
It did.
to dictate and get everything done. So, Matthew, your February 12th correspondence is deeply concerning. Not because of the subject matter itself, but because of what it reveals about the manner in which this litigation is being conducted. For months, I have attempted in writing to address material significant financial issues affecting the marital estate, and by extension, our children's long-term stability. I need to pause this for a sec, the letter, and explain that I got an email saying my son's finger was really hurt. I was not communicated with or let know anything about this. I am so concerned about my son's health and safety, and none of that was addressed in the email other than an accusation and a gasoline fire that Matthew Smora thinks he's going to start. So let's keep going. For months, I have attempted in writing to address material significant financial issues affecting the marital estate and, by extension, our children's long-term stability. Those communications have focused on mortgage default, exposure, prevention of marital equity in a residence, prevention of marital equity in a residence valued in the multi-million-dollar range, and refinancing options, structured liquidity solutions, and the avoidance of unnecessary dissipation of assets through escalating legal fees. Those issues remain largely unaddressed. Instead, I received an accusatory email alleging impermissible removal, not that I could have done it by accident if I do have this item, whatever it is, of ski clothing during a 1-hour court authorized police escorted retrieval that was recorded in its entirety on law enforcement body camera. The disparity in propriety is striking. We are facing a $5 million lawsuit, and I'm sorry about that. I apologize. This is just so well written, and it is so indicative of the bullshit that I have to deal with, where instead of focusing on work-related matters and generating income, I have to, in real life, be able to read this email and then respond to him. This is an email from me to him, from me to Matthew Smora. We are facing a $5 million marital residence with foreclosure exposure, significant marital assets capable of refinancing or restructuring, ongoing pendent lite obligations currently on appeal, a complete breakdown in co-parenting communications, 5 months during which I have not seen or spoken to my children, dismissal of the criminal charges previously used to justify extraordinary restrictions. And yet your office elects to escalate a dispute over winter clothing accessories? That posture is not proportional advocacy. 1. Failure to address substantive financial issues. I have repeatedly raised in writing the following issues. 1. Mortgage default and foreclosure risk. 2. The need to refinance and restructure the marital debt. 3. Preservation of equity before unnecessary dissipation. 4. Coordination regarding marital assets that can fund the children's lifestyle without destructive litigation. And 5. Transparency concerning financial management of estate property. These communications have not received substantive response. Under the rules of professional conduct, RPC, which govern how lawyers work in case you're wondering, counsel has a duty of candor and fairness in dealing with opposing parties, RPC 3.4. By the way, I pointed this RPC out to him about 100 times. And must refrain from conduct prejudicial to the administration of justice, RPC 8.4. D. Selectively ignoring substantial financial exposure while aggressively communicating over trivial personal property disputes raises legitimate concerns regarding litigation, proportionality, and professional judgment. Aquaphor. I am not making accusations of misconduct. I am documenting a pattern. Do you understand what that means, Matthew? This is the same guy that makes fun of me because I say the word metadata in court. When essential financial issues affecting the children's long-term stability are left unaddressed, but minor personal property disputes are escalated immediately, it suggests that conflict, rather than resolution, is being prioritized. This is not in the children's best interest. 2. 5 months without parenting time. It bears repeating. I have not seen my children in over 5 months. The criminal charges previously pending against me have been dismissed. There's no current criminal predicate supporting indefinite exclusion from parenting time. Yet I remain without meaningful access, without transparency regarding my children's activities, and without even being informed of a planned events such as a ski trip. It is profoundly disturbing that I learned about my children's winter activities through an accusatory email rather than co-parenting communication. As their father, I fully support their participation in school and recreational activities. I have always supported them. I have funded those activities. I have purchased the very clothing now referenced. Support requires communication, Matthew. Exclusion does not. 3. The allegation is unsupported. Your email asserts that I impermissibly removed, in quotes, children's ski clothing and related items. That allegation is not grounded in fact. My access to the resident was strictly limited by court order, narrowly defined in scope, conducted under continuous police supervision, and recorded in full view of body cameras. At no time did I exceed the parameters set forth by the court or law enforcement. If there is a claim that specific items are currently in my possession, I request that those items be identified with precision. Generalizing accusations are not appropriate. First and foremost, we have 2 little kids at home, and Mal is managing a 9,000 square foot home, quote, by herself. So the idea of maybe she lost an item is not what is on the table. Meaning that, hey, Dan, can you check to see if you accidentally took some of the boys this and this? That's not what happened. A completely accusatory, insulting email, which first spiked my concerns because my son his finger was injured. So him going skiing with an injured finger might not be the best idea. Next. The suggestion that I engaged in misconduct during a supervised retrieval is frankly embarrassing to read in light of the objective record. Nevertheless, if specific items are identified and demonstrably belong to the children, I will cooperate in arranging for their return through the Livingston Police Department. I will not, however, accept vague accusations intended to inflame conflict. 4. Proportionality and litigation conduct. The administration of justice requires proportionality. When counsel ignores communication regarding a multi-million-dollar asset in distress while urgently escalating a dispute over winter accessories valued at a fraction of one mortgage payment, the optics are difficult to reconcile. Litigation should not be weaponized to generate unnecessary friction, particularly where each communication incurs additional legal expense ultimately borne by the marital estate. The children's welfare is not advanced by arguing over gloves. It is advanced by protecting equity, avoiding foreclosure, preserving liquidity, reducing unnecessary attorney-driven conflicts, and restoring meaningful parental involvement. If your office wishes to engage conductively regarding mortgage restructuring, asset preservation, or practical financial solutions that support the children's needs without destroying the estate, I remain available. 5. Notice regarding record preservation. Given the ongoing appeal of Pende Lite order and the broader procedural posture of this case, I am preserving all correspondence. I mean, they're public on one of the most coolest YouTube channel. Okay. If there is a legitimate dispute regarding specific property, identify it. If there are substantive financial issues affecting the children's stability, address them. If parenting time remains restricted despite dismissal of charges, explain the legal basis. I will continue to respond professionally and within the lawful channels. 6. Conclusion. I categorically deny that I impermissibly removed the children's property. If specific items are identified and demonstratively belong to the children, I will cooperate with their return. I remain prepared to address the meaningful financial issues affecting the marital estate and the children's future. What I will not do is participate in peripheral escalation while the core issues foreclosure exposure, asset preservation, and restoration of parental involvement remain unaddressed. I expect future communication to reflect the seriousness of those issues. Daniel. P.S. Separately, I must address an ongoing issue directly impacting my ability to comply with the existing court directives. There's currently a court order requirement that I pursue refinancing of the marital residence within a defined lifetime frame. That process requires cooperation, documentation, and coordination access to financial information. Without your client's cooperation and timely response to reasonably request the documents and coordination, compliance becomes structurally impossible. In short, for anyone at home that doesn't understand, Mallory is expecting me to generate money while not giving me access to my office, my records, my inventory, anything. She doesn't even ship the items sold on the eBay account that she herself listed while demanding me to pay for things. Her lack of cooperation is exactly where we're getting divorced. She has destroyed every single project ever started by me and has specifically went out of her way, other than my real estate, which was stolen by other people. But she did steal or try to steal a few items of real estate, and you'll see. In addition, there was a prior instance in which an income-producing asset, an eBay sale item, was not permitted to be turned over to me, despite repeated written requests. That decision directly impaired my ability to generate funds towards court-ordered obligations. I preserved all correspondence regarding the issue. I am again requesting the prompt cooperation on refinance-related documentation and asset coordination so that I may comply with the court's directive within the requested 45-day window. If I do not receive substantive response in a reasonable time frame, I will have no choice but to seek appropriate relief from the court to address non-cooperation and the impossibility of performance. I would prefer to avoid additional motion practice and the added expense to both parties. I remain willing to resolve these issues constructively. At 9:09 p.m., this is his request. Mr. Reeses, pursuant to your request, below is a specific list of items that Ms. Reeses requests that you return through the Livingston Police Department tomorrow morning. 1 black and white children's helmet, 1 snowsuit, a women's snowsuit that is black and white. Hold on a second. How is a women's snowsuit children's clothing? Jamie, is a women's children's?
Nah.
All right. So now I'm being accused of taking Mallory's snowsuit, I'm assuming, right? So now that's the second accusation. 1 pair of blue and yellow mirrored youth goggles, 1 pair of black mirrored youth goggles, 1 pair of white goggles with silver lenses, youth-size thermals, women's thermals, ski socks, dash Mats Moro. Excellent. So he gave me the list of items that he believes that I took inadvertently. Now, Jamie, can I please have... Dear counsel, as clearly demonstrated by your complete ignorance of the core material issues that I addressed in my email, I will now be filing an emergency order to show cause and requesting a full psychiatric evaluation for you personally, because there's no human being that can charge money to their client, read an email which clearly addresses millions of dollars in assets that are being burnt in order to fuel litigation, and you're able to ignore all of this and give me a list of garbage that you think that I inadvertently took. You also lied once again, and you are requesting some article of clothing that belongs to Mallory. That is a material lie, and you are no longer representing Mallory, which means that I am now instilling several RPCs which state that I will be filing. We've already filed a police report against him.
I think so.
I believe we did.
I think so. Yeah.
I believe we did in Livingston.
Yeah. Like
And if we haven't,
yeah.
he committed a crime.
Yeah.
Police
Yes, you did.
report,
Yeah.
and the fact that we're suing you in two separate or one separate venue.
One and
One-
then added two to be added later.
Okay. I will be filing several emergency order to show causes, including one of the motions to have you personally removed as counsel representing Mallory due to your most recent actions and your complete and utter incompetence, that by virtue of ignoring the core issues, but only addressing the basic needs of the kids that you think that I am able to get immediately. You also do not identify where my children are going, whom they're going with, and why I haven't been notified of my son's injuries. I also am disturbed by your complete ignorance of the actual court orders that have been issued and your client's inability to cooperate in the most basic sense. And lastly, there are two items that must be shipped. The last previous item that was not shipped not only cost me $650, the account was officially restricted. If these items are not shipped, the account will be canceled, at which point I will be filing motions for summary judgment, and I will 100% win. Because what your client will effectively have done is literally lied under oath to prevent me from running my business, and then destroyed the business when I wasn't able to run it, while she had access to the inventory and I did not. This concludes my letter, and this concludes this video, because the whole point, Jamie, you need to get ready to press off when I say this concludes this video, okay? So, ladies and gentlemen, as you see, this is why this is a beta test. There's a lot of back and forth, and Miss Resnick got lost in her own thoughts, I guess.
Oh, I was gonna go get the phone, yeah.
I
I know, you didn't give me a direction to do
I didn't say to go get the phone, Miss Resnick. So I'm having a really hard time. So most likely, Miss Resnick's current capacity will be shifted a little bit, because as much as she really does an amazing job in administrative functions. Oh, by the way, I just want to remind everyone that she's an unbelievable mom and an amazing assistant, but I'm not able to have any communications with her without her getting super upset, which prevents her from doing her job in reality and makes me look like a huge jerk. So it is physically impossible for me to continue to, so for example, right now she's making faces off camera. If a producer ever did anything like that, they would actually never be allowed on the studio, let alone working in production. No matter how many times I ask her to please follow basic directions or I get upset, it is virtually impossible to get it done. I believe that she has a significant amount of value that can never be replaced, but as you see, ladies and gentlemen, Jamie is absolutely amazing, and I need her to turn this camera off, because I didn't say off yet. Thank you. Please get ready to turn it off. Ladies and gentlemen, what I do is extremely difficult. It is raw, it is real, and because of what Matthew Samora just wrote to me regarding the fact that my wife is planning on taking my children skiing, even if it's for the day, without me even knowing where my children will be, how their lives will be risked, meaning that skiing is a risky activity. It is, in my opinion, not safe to have one adult with her, And I would like to know what other adults will be supervising my children. I need to know the names and the information. And there are certain basic things that I can't express to anyone how much they affect me. And for anyone that's wondering what I was expressing regarding Jamie's position, it is on the production side. What my goal is to get my assets back, unwind this ball of mess that was created for me, and have professional camera operators and a professional producer running the production end of it. Rather than understanding that aspect of it, Ms. Resnick got extremely upset. That is because communication is very difficult for her, as identified earlier. A lot of that has to do with me and the changes that I need to continuously make as a boss. And I end up being extremely tired, frustrated, and showing the worst of myself. This is why she is no longer on camera, because sometimes human beings bring out the best in other human beings, and other times they bring out the worst. And I realized that I started bringing out the worst in Miss Resnick, and I don't want to do that. I think she's an amazing mom. Today she told me an amazing story about softball and how she played on this awesome team called Tricious Girls, and the story about how everyone was part of a family that was able to bring their children, and everyone had young kids. And what's fascinating to me is that we live in a town of women who fully support a woman who they know is an amazing mother having her kids taken from her, because I've not seen a single person from Tricious Girls who knows that you're an incredible mother, would never hurt anyone, reach out to you one time. And I hope all of them really can look in the mirror to see just how rotten of a soul they have, or how much fear they have in the community that is so disgustingly abusive by showing human beings that they care for them and then destroying them should that human make a mistake in their eyes, not in reality. Jamie Resnick is one of the best humans I've ever met in my life, let alone a mother, let alone an assistant. She is the best assistant I will ever have. I understand this. A lot of that has to do with the fact that she herself has incredible talent. There's also the element of how difficult I am as a human being, which I recognize with every breath that I take. At the same time, people who are human beings that watch this channel have to watch me stay calm no matter what happens. Ladies and gentlemen, my name is Daniel M. Reeses, and in order for me to make a 3-minute audio file, I had to spend almost whatever length of time in this video with the preamble, the work that I have to do, and the work that I'm not doing, which is generating an income for my family, all because of my wife's inability to communicate. My name is Daniel M. Reeses, and I hope I have taught everyone a lesson, and that lesson is: don't sweat the small stuff.